Now the application by a former personal assistant of the then Free State Premier Ace Magashule in a bid to have her arrest declared unlawful has been dismissed with costs. Moroadi Cholota is facing fraud and corruption charges in relation to the 255 million rand asbestos roof removal scandal in the province. The 37-year-old was extradited from the US, is currently out on 2,500 rand bail. She's accused of fraud and corruption amongst other things, as I mentioned. Watching a story for us is SABC News reporter Ishmael Modiba, who joins us now live. What were some of the reasons that were outlined by the courts, Ishmael, in dismissing this application?
Well, at this stage, I cannot give you any reasons because there were not reasons forwarded. All I can say is that Judge Dennis Nkutsa only said that the case is dismissed with cost. And one thing that I have noticed, because I've been doing courts for so many years and I've got interest in covering court stories, it doesn't matter whether it's a lower court and upper court, but what I've discovered today was this judgment only took less than 15 seconds to give. So that was one of the interesting things that I've observed. But obviously, that's how the judgment was given. And obviously, when they do give this kind of judgment later on during the day, the lawyers for the accused is the applicant is the one that will be forwarded with the reasons. But to tell us more with regard to why we ended up being here is the instructing attorney of Moroadi Cholota, that is Pete Tibane. I just want to bring him into the picture just to get a feel as the legal representative. What is their next move after the judgment that was delivered here in the Free State High Court? Pete, you were inside court, and it didn't take long for Judge Dennis Nkutsa to deliver the judgment. But first thing first, let's speak how did we ended up being where we are today?
All right. When we approached the court, we had about 4 prayers that we were looking for. One was to challenge the constitutionality, the conduct of the state through their prosecution and the investigation officer. Number 2, the unlawfulness of the charges. Number 3, for the court to direct the DPP to squash the charges. Number 4, it was to declare the extradition unlawful. And the effect of that, to an extent that the court ruled in our favor that the extradition was unlawful, what it means, the South African court will not have a jurisdiction. You will recall, among other things, we started this case from the Constitutional Court, but the state, from the Constitutional Court to the Magistrate Court when we apply for bail, and to this court, they've been giving 3 different versions. The version that they gave at the Constitutional Court, or the reason why they said why they charged our client, is because she refused to implicate the former Premier of Free State, Mr. Ace Magashule. When we moved to we go for bail application, they provided a different reason. They said the reason why they decided not to charge is because she cooperated to appear at the state capture, notwithstanding the fact that it has never been a condition that for her not to be charged, she needs to cooperate at the state capture. When we came to this court, they provided a different reason. We still believe that the manner in which our client was brought in this country was unlawful, and it renders the court unconstitutional. But obviously, as you have stated at the beginning, they delivered the judgment, but we don't have a copy yet to read the reason. What we intend to do, we need to consider what are the reason, then we consider what are the next option. But we'll definitely see what to do and take instruction from client.
I was going to ask you what is the next option, but also considering the fact that you've got another matter that is next month on the 4th or 7th of February, where there is a pre-trial conference that is supposed to, prepare for the trial that is being set for March to June this year.
We do understand that we are not dealing with collective rights. We're dealing with the rights of our client. And our client, to an extent that after perusing the reason, we believe that another judge is likely to rule differently. We are going to take that option. In as far as the date of April, the prosecution will deal with that. When they set the date, obviously they have never considered our client. Our client joined the matter very late, and we will not allow anyone to bully us to attend the trial to an extent that we intend to explore other avenues. But obviously it will depend what are the reasons that have been provided. But as I've stated, without me repeating myself, our client is accused number 17. She joined the matter very late. The other accused, they have plenty time to consider various options. And to an extent that our client give us an instruction to consider other avenue. We're going to do so. In as far as the date, we will see how we deal with it. We're coming back here on the 7th to inform the court whether we'll be ready or not. But obviously, this court judgment might have an implication on that, depending on what the instruction will be.
Thank you very much for your time and good luck going forward.
Thank you.
Well, Ayanda, that is the situation here at the Bloemfontein High Court. You heard what Pete Dibane, the instructing lawyer of Moroadi Cholota, has to say. And I can tell you with certainty that I don't foresee the trial that is set for March and up until June going forward, because the intention from what he's saying is clear that they're still going to pursue this matter because they need to be prepared. Because previously, when they were arguing this matter, preparing for the pre-trial, they also spoke about the voluminous nature of documents that they have to go through. And the indication from where we just, I was speaking to him, he's saying that they still got a long way to prepare. So my feeling for now is we're still going to see a lot of delay in this matter. As he's saying, other applicants or accused in this matter had ample time to prepare. But that is the situation right here in the Bloemfontein and the Free State High Court.